do have skills that make me a nightmare for people like you.
Thank you, Ms. Jane.
May it please the Commissioners, I call to the witness, and they are there, Dr. Peter Wilkinson and Professor Des Cahill. Chair, I will leave you to administer.
Gentlemen, as we start, the New Zealand Inquiries Act 2013 requires me to ask you both and to receive an answer to this question. Do you solemnly, sincerely and truly declare and affirm that the evidence you will give before this Commission will be the truth, the whole truth and nothing but the truth?
I do.
Thank you.
Before we start, could you each please state for the record your full name?
Peter Julian Wilkinson.
Thank you.
Desmond Philip Carl.
And together you have produced a comprehensive paper with appendices which has been provided to the Commission, and that is, to the best of your knowledge, true and correct as the time it was written?
Correct. Correct, yes.
And you've also produced a shorter summary paper which you are going to be presenting today.
Correct, correct.
Chair, with your leave, I will produce the shorter paper as an exhibit. I'm not quite sure what number we're up.
Thank you.
Not working? 60. Thank you. Professor Cahill, could you start, please, with the introductory remarks that you would like to make? But prior to that, could I ask you to provide background and experience, and also Dr. Wilkinson, so that the Commissioners understand the basis on which you're providing expert evidence today?
Thank you, Madam Counsel. Firstly, may I make it clear that I am not a victim. I was ordained a Catholic priest in 1970 after studying in the Melbourne Seminary, and then I was sent to Rome, where I did my 4 years theology. I came back and I worked for 6 years, and then I decided to do a career switch. I married and am now a very happy husband, father and grandfather. And then I embarked on an academic career, and I became a trained psychologist, but I focused on the areas of immigrant and refugee movements, cross-cultural communication, second language education, and then on multicultural and multi-faith societies. I am now the Chair of Religions for Peace, which is the world's largest interfaith organisation, and I am Deputy Moderator of Religions for Peace Asia. My engagement with the child sex abuse by clerics began really way back, but it was in 2012 that I made a submission to the Victorian Parliamentary Inquiry into institutional responses to child sex abuse, and I was called up on day 2. Initially, interestingly enough, to give evidence on child sex abuse in the non-Christian religions, because we know that there are significant problems in countries like India, Thailand and Indonesia with the issue of child sexual abuse in ashrams, in temples and in boarding schools. In 2014, I was asked to go to...
Mr. Carhill, can I intervene for just a moment, and I'm sure you'll realise why. When you speak, the stenotyper in front of you is taking it down, and the signers are also keeping up with what you're saying. So if you would be good enough to moderate your pace by looking at them, you will get the notion of speaking at a rate where it can all be transcribed.
Thank you, Chair.
Thank you.
I'm too used to lecturing. So I went to a workshop in Spain organised by the International Institute of Sociology and the Law that focused on sex abuse in the Catholic Church, which brought together the world's leading scholars and researchers. After that, I was asked by the Australian Royal Commission to be the senior consultant on the Catholic Church to the Commission, and so I worked with my colleague Peter Wilkinson to produce the RMIT report, which, when it was released, went global. More recently, I was asked to go to London to give advice to the UK's independent inquiry into child sex abuse, commonly known as the Jimmy Savile inquiry, and now I've been asked to come here, so I appreciate the opportunity for you to hear of our expertise and the insights that we hope we bring to your considerations.
Thank you, Professor Cahill. Dr. Wilkinson.
I'm a Melbourne boy, and at the age of 18, I was admitted to the seminary of the Missionary Society of St. Columban, and I was ordained in 1961 as a Catholic priest, and did my postgraduate studies in Rome on 2 occasions, first for a licentiate in missiology and then a doctorate in missiology. I taught in the Columban Seminary in Melbourne and also in Sydney for approximately 4 years, and after receiving my doctorate I was appointed to South Korea to work as a missionary there, and was there for 4 years. Then I decided to seek laicization in order to marry, and at the moment I am married, and I have 4 adult children and 4 grandchildren. My association with the subject of child sexual abuse began, I think, in 2010, when I was asked to join a small renewal group in Australia called Catholics of the Ministry. And at that time I wasn't particularly interested in church matters, and my approach was to buy a copy of the Australian Catholic Directory and examine it as a piece of research. And what I found was that, looking at the evidence, there was a serious crisis within parish ministry in Australia. And looking further, it became clear that one of the causes of this crisis was child sexual abuse in the Catholic Church in Australia. So I had 2 reports on parish ministry published. Also at around that time, another group formed in Melbourne, and we called ourselves Catholics for Renewal. And one of the first actions of that group was to write a letter to Pope Benedict XV and all the bishops of Australia, and state that the Church was in crisis, and that the question of child sexual abuse had to be addressed openly if the Church in Australia was to be Christ-centred. We also, at that time also, the Victorian Parliamentary Inquiry was set up. So our group decided that we would make a submission to the Victorian Victorian Parliamentary Inquiry, and that the subject of our submission would be good governance, which we believed was lacking. We also argued that the Victorian Government should establish mandatory criminal reporting for instances of child sexual abuse. The recommendation of the report, Betrayal of Trust, recommended that action be taken by the Victorian Parliament, and it did. Des has already spoken about our work with RMIT and what we did in regard to the Australian Royal Commission. Thank you.
That provides a very good context, so I now invite you to begin with your introduction.
Well, I'd like to congratulate the government and the people of New Zealand for conducting this high-level inquiry into child abuse, and to have included in its terms of reference both government-based and faith-based institutions. As we've learnt this morning, the road to this Royal Commission has been long and arduous, particularly for the victims' survivors. Their suffering must be paramount in our minds and hearts. Our focus, as we've already indicated, will be on child sex abuse in faith-based institutions, but particularly the Catholic Church. Of course, this is not New Zealand's first Royal Commission into child sexual abuse. In August 1900, a short Royal Commission investigated the Maris Brothers Stoke residential facility outside Nelson. The Commission's report found much to criticise in its management, staff and standard of care. And the Maris Brothers eventually were forced to vacate that facility. So the physical, emotional and sexual abuse of children, even though it occurs more often in families, and we need to keep that in mind, is a scourge. And in Christian history, we can trace it back to the New Testament times, when the paterfamilias would abuse the slave boys and slave young women of his household. And in our RMIT report, we document that the examples throughout history where it has happened, as much as we know. One outstanding example that is relevant to Australia and New Zealand was that in 1871, Mother Mary MacKillop, Australia's first saint, whose Josephite nuns came to New Zealand in 1880, was excommunicated by the Bishop of Adelaide. And one of the major reasons was because she had been a whistleblower on a parish priest in a rural parish outside Adelaide, on a parish priest who was sexually abusing children attending the nuns' school. The priest, other priests and the bishop were all Franciscans, and they ganged up on her, and she was excommunicated. The real reason for her excommunication was kept hidden from the Australian and New Zealand communities, Catholic communities, for more than 140 years. And one wonders what salutary effect knowledge of this incident might have had on religious offenders in subsequent decades. The Irish Christian Brothers who came to Dunedin in 1876. In Australia, the first one was jailed in 1919, and that particular religious order had problems in every decade of the 20th century. The Christian Church has always condemned child sex abuse, but unfortunately in recent decades has seen it as a sin and not as a crime. And so we've had, as we've heard this morning, the ravaged innocence of the child abused, assaulted, violated, raped and sodomized. And that lies at the centre of this religious catastrophe. In the Christian tradition, children are seen as close to the mystery of God. Each and every child is embraced in God's infinite tenderness. And for parents to have their patient, time-consuming and loving handiwork of raising a child damaged and destroyed by abusing clergy and religious is at the very core of this religious tragedy. In educating our children about their own self-protection, I like to use the very useful Christian maxim highlighting bodily ownership and integrity. No trespassing. This is my body. It cannot be denied that the public image of the Catholic priesthood and religious life has been irrevocably damaged. This has impacted upon the public image and self-image of countless good, committed and saintly priests who have dedicated their lives ministering to the Catholic communities here in New Zealand and across the world. And I suppose this has shown to us that there needs to be a thoroughgoing renewal of the Catholic priestly ministry, including the abrogation of mandatory celibacy, though this would not be a panacea. And we've just, in the last 2 weeks, seen that process begin in Rome with the findings of the Amazon Synod, driven by the desire of Pope Francis to reform the Church. I'd like to make a few reflections, Madam Counsel. Child sex abuse is always about power and the abuse of power. Power corrupts, and ecclesiastical power corrupts ecclesiastically. Pathologies can infect any organisation. Further, child sex abuse is always hidden, very hidden. Hidden by the priest and religious perpetrator, and that is why it is so insidious. The crime takes place in secret, and the victim is neutralised into silence. We'll come back to that point. The Australian Royal Commission found very little evidence of pedophile rings in religious settings. An additional reflection that I want to make is this. Priests and religious offenders are very great deniers, continually and determinedly protesting the denial of their own criminal behaviour. And some Catholic bishops and religious leaders have found this to their great cost. And the higher up the church hierarchy, the offender, the more determined is the denial. And so we have to understand this within the parameters of dysfunctional governance. And we'll be emphasising this during our presentation. The lack of transparency and accountability, all within the culture of secretive clericalism and within its flawed selection, screening and training processes in previous decades and centuries.
And you've set yourself 4 tasks for today, which you outline on page 5. Perhaps you could just quickly summarise those and then we'll start moving through them.
Okay. Well, we want to bring to your attention the recommendations of the various government-sponsored and church-sponsored inquiries, because we were asked by the Australian Royal Commission to look at 27 Australian and international inquiries, to present the findings, some of the findings and recommendations of the Australian Royal Commission, which are contained in volume 16 of the 7,400 page report, to give you a roadmap for understanding why it happened, and then to present some ways forward for you here in New Zealand, and then we'll address some special issues which Peter will do about mandatory reporting, the religious confession redress issues.
So for this specific inquiry, terms of reference 20D requires our Commission to have regard to information and evidence from other inquiries and reviews. And you have evidence about the Australian Royal Commission. I'd now invite you to go through that section.
The Australian Royal Commission's figures showed that 572 priests, 597 brothers, as well as 543 laypersons sexually offended in Catholic settings against children, usually boys, about 70%. Comparable to the US evidence, and using the weighted figures, that between 1950 and 2012, 1 in 13 diocesan priests, 1 in 17 religious order priests sexually offended against children under 18. The offending was worst in regional dioceses, and the least was in the Archdiocese of Adelaide. An estimated 1 in 8 religious brothers sexually offended against children, especially amongst the St. John of God brothers who care for mentally disabled children, as well as the Christian brothers, the Maris brothers, and the De La Salle brothers teaching in orphanages, daytime and boarding schools. When we look at the New Zealand context, there is nothing to suggest in historical terms, based on the prevalence data in comparable countries, that the offending rate in New Zealand diocesan priests would not be in the range of 5 to 7% and 2 to 5% amongst religious order priests. Although it may be lower because fewer male religious priests had charge of schools and youth ministries. New Zealand has always had a relatively high proportion of religious order priests compared to diocesan priests, and this may have had a dampening effect of offending priests and the number of victims. There's other reasons why amongst religious brothers it may be less than the Australian rate. Firstly, New Zealand was less impacted by the child migration scheme. And there's a long history to that. Secondly, New Zealand moved
Professor,
several...
Would you just be able to explain the difference between the diocesan priest and the religious order priest for us? Yes, I don't think it'll be clear to everyone.
Right.
Thank you.
A diocesan priest is one who is ordained and incarnated, is a technical term, into a particular diocese. A religious order priests, such as the Jesuits, the Marists, they are called religious order priests because they were founded by a specific founder, like St. Mary of the Cross, okay? Some of those may work in parishes, but others may work in schools, in universities, in welfare groups, advocacy groups, all sorts of other kinds of work that the church is engaged in across the world. Okay? The second point I was going to make is that New Zealand seems to have moved a little bit earlier than Australia and Ireland away from large-scale orphanages to foster care arrangements, which again are not without their problems. The exception is the Catholic boarding schools, but their number has greatly declined in the post-World War II period. The third reason we think is that, through Peter's research particularly, is that the number of religious brothers in New Zealand has been relatively modest, 116 at the moment, and it peaked at 385 in 1966. And we also note that in the post-War II period, all the Catholic orphanages, as we understand it, were being run by female religious orders. Now, I need to talk about the nuns. The Australian figures show that there was very little sexual offending by nuns. Sometimes, through sheer sexual naivety, they did permit priests and handymen to have access to children in their orphanages. However, both the relevant Australian and Irish reports have documented serious emotional and physical abuse by nuns against children in their residential care institutions. So also many former inmates regard their nun carers with love and affection. Now, I think we need to explain the very high offending rate amongst religious brothers. The central factor was their lack of interface with the feminine. Whilst this has now partially changed, their contact with women was generally minimal, beginning with the fact that they were educated usually in male-only schools, went to male-only juniorates, novitiates and scholasticates, and then they went on. They did go to university, but they were then appointed to male-only schools and lived in all-male religious communities. This was a recipe for a psycho-spiritual disaster. The Irish Ryan report has studied this best, and they highlight within the Christian Brothers their failure to appreciate the emotional needs of the children in their care, or to pursue appropriate training in community child and youth welfare. It documented their lack of an acknowledgement of congregational responsibility for what happened, the consequences of the regime of blind obedience with its humiliating punishments, their fear of change, the lack of institutional memory, and their use of government funds to cross-subsidise other activities. Their psychological fear of women were factors that operated across their structures, but also right across the structures of the Catholic Church, both in its decision-making structures and in its ordained ministry. And while there is much talk, very little seems to be changing in the Catholic Church, although with the recent Amazonian Synod 2 weeks ago, Pope Francis will look at the issue of the female diaconate, but amongst traditionalist Catholics, they have gone ballistic in their opposition. Now, terrible as these statistics are, they must be balanced by the fact that 59% of Catholic priest offenders had only one claim of redress against them. This suggests they had only one victim who perhaps was abused many times. And from our own research, we know that the probability of a young Catholic child being abused in a religious setting was always relatively small but not low. It ranged from about 1 in 200 to 1 in 400. The risk, however, was very much higher for boys, especially if they were altar boys and choir boys, and it was very high for boys in Catholic residential institutions, cared for by religious brothers. We know from the American data that when altar girls were introduced in the 1980s, the rate of abusing of both the altar boys and girls was about equal. And this brings up the issue of access, and we'll talk about that. This brings up the issue, as we heard this morning, of the serial predator priest and brother who abused at least 10 children. And we know that the serial offender Jared Ridsdale in Australia abused more than 100 children. Another offending category is the recycled seminarian. The one who began training in one seminary was asked to leave and then was accepted by another seminary. So this has happened right across the world, we now know. And so there have been inquiries that we looked at in the US, 7, Canada 2, England and Wales 2, Ireland 4, Belgium 1 that was never finished, and the Netherlands. But I must say that none has been as well funded or as thorough or as detailed as the Australian Royal Commission. in September 2018, a year ago, the German Catholic bishops published a very useful research report. And last night, the French bishops received a draft report of their research study. So the Australian methodology was built around private sessions and written accounts, and then the Prime Minister in October last year made a formal apology in Parliament to all survivors, as well as those who didn't survive through natural death or suicide. The Royal Commission subpoenaed 1.2 million documents, and its other major strategy was to conduct 57 case studies. The Commission made 2,250 referrals to the police, and exactly half of those related to religious settings, and those are now working through police investigation and criminal justice processes.
And we'll return a little later to talk about additional matters relating to the Australian Royal Commission. But before moving to that, there were some myths that you thought it was important to discuss and why they should be looked at differently.
Yes. In Australia as elsewhere, some Catholics have accused the various government inquiries, such as this one, of conducting anti-Catholic vendettas. Now, anti-Catholicism, anti-clericalism has always been around. Other Catholics have accused the inquiries, have been disapproving of the media and its journalists, alleging that they're exaggerating its scope and repeating over and again the same material, and certainly there has been some of this. But it's been journalists, together with female researchers and priest and ex-priests, researchers, particularly psychologists, who have brought this out into the open. And when we look at the figures, except for the Jehovah's Witnesses, no other religious group came close to the Catholic Church in the level of offending, though the Anglican level was relatively high. And the Jehovah's Witness contains instances of family abuse that was mishandled by the elder. The second myth is that clerical sex abuse occurred only after World War II, and it was made worse by the sexual revolution of the 1960s and the Second Vatican Council in the 1960s, and the general climate of secular and Catholic libertine liberalism, which led priests and religious to experiment. But based on our research evidence, we've concluded that the Holy See, the Vatican, knew right throughout the 20th century, as we can see in the 1922 instruction, Crimen Sollicitationis, the crime of solicitation, which was reissued in 1960. Now, sexual soliciting by means of the confessional has always been a problem for the Church, and the situation was made worse in 1910 by Pope Pius X, when he lowered the age of confession from 12, 13 to 7, 8 years of age. Now, this second myth was driven especially by two very good John Jay reports. John Jay is the John Jay Centre for Criminal Justice Administration attached to the University of New York. And it was commissioned by the US Catholic bishops. And it produced wonderful data, as we'll be emphasising. But unfortunately, it gave credence to this myth. And it started its study in 1950 in its data, whereas it really should have gone back further. But we don't have proper data for the first half of the 20th century. But we now know, but we'll never be able to quantify it, to compare it with later decades.
And can I just confirm that in your evidence you talk about two John Jay reports, one in 2004 and another one in 2011? Thank you.
Yes, the first one was collecting data from all the dioceses across the United States, okay? And it was only focused on dioceses and diocesan priests, unlike the Australian Royal Commission, which was much broader, okay? And the second one looked at associated but other issues between 2004 and 2011.
And you set out the basis of the data available. If you could go through that, that would be helpful.
Yes. I need to mention also that this second myth has been perpetuated in a recent letter, a very unfortunate letter, by Emeritus Pope Benedict XVI. Unfortunately. Now, there was a rise in offending during the 1950s, into the 1960s, the 1970s, and the first part of the 1980s. And later on we'll talk about why. But let us think about why there was this rise. There was greater access to vulnerable children in the aftermath of the Second World War, where there were increased numbers of such children in orphanages, including migrant children as well, and children who are orphaned, abandoned, and displaced as a result of the Second World War and wartime dalliances, let us say. There was a marked increase in the Catholic population in the migrant-receiving countries such as Australia. So there was pressure on the bishops to fill vacant parishes as the Catholic population and expanded, and they sometimes ordained less than suitable priests who simply should not have been ordained. And there was remarkable episcopal irresponsibility in rejecting the advice of seminary staff. There was the changing lifestyle of the priests, the proliferation of one-priest presbyteries from the 1960s, the greater and easier mobility with access to cars from the 1930s by the priests, and as a consequence, less monitoring of priestly activity and less accountability. And also there was an increasingly positive image of the Catholic priesthood, and that attracted altruistic young men who were prepared to accept mandatory celibacy as part of the priesthood package without fully understanding the commitment. There was a greater access to children through growth of schools, youth clubs, Boy Scouts, etc. And there was also greater turbulence in the church immediately and during the Second Vatican Council, which may have had an unsettling effect upon priests. And there was the impact of the sexual revolution, but I think that's just one factor. And lastly, there was a deep rejection by the Catholic faithful of the Church's theology of sexuality, based on the interlinking of sexuality and procreation following the encyclical Humanae Vitae and the condemnation of artificial contraception, with the result that the Church was unable to offer a credible and acceptable theology of sexuality, a situation that still exists today.
And to try and help us understand how and why clerical abuse of children occurs, you've actually identified what you call a constellation of features, and you have 5 of those. And you will set out A to D, and then Dr. Wilkinson will talk to E.
To one, yeah. All right, let's begin with the first factor, which is the psychosexual abnormalities and situational factors. Our reading of the literature points to the central conclusion that young and vulnerable Catholic children, especially boys, were in danger and at risk in the presence of psychosexually immature, psychosexually maldeveloped, and sexually deprived and deeply frustrated male priests and male religious, especially those who had not satisfactorily resolved their own sexual identity. Psychosexual maldevelopment was usually, not always, but usually associated with the religious perpetrators themselves being sexually abused during their childhood. And this occurred to about 1/3 of the priest perpetrators. And the notorious Australian serial priest offender, Jared Ridsdale, was abused by his uncle, his cousin, and a religious offender. This offending behaviour was also mediated, and I know this is complex, but was mediated by a set of cognitive and emotional distortions, denial mechanisms, and neutralization techniques. And behind that were the theological ideas of a patriarchal idea of God that lacked intimacy and closeness in their spirituality. There was a sacrificial theology of priesthood based on their own divine calling as priests and brothers. There was the flawed theology of sexuality that I've referred to. And as well as that, there was a set of psychological realities, an unresolved sexual identity, an ungrieved loss of sexual intimacy in their celibate commitment, and overwhelming feelings of emotional loneliness. As well as that, I'll draw on the German study, that they were often in stressful situations. Firstly, a general sense of overburdened with official duties or problems in their ministry, isolation and loneliness, substance abuse, alcohol, medicines, illegal drugs, inadequate social skills, particularly interacting with parishioners due to their immaturity, and particular stress or changes or difficulties related to their personal circumstances, such as financial problems, illness, or caring for or death of relatives. This issue of sexual identity raises the whole issue of confusion or denial about those with a homosexual orientation and their training and operating in a profoundly homophobic church environment. There's little psychological evidence that the priest and religious offenders were suffering from psychotic illnesses. In fact, most of the offenders were talented and attractive men. And they're better educated, have higher IQ than the normal child sex offender. They came from intact families. But there was evidence of a pattern where discussion of sex in the family was taboo, where the father was generally distant and aloof, perhaps alcoholic or physically abusive, while the mother was a smothering mother, perhaps vicariously covering up her own unhappiness through her son, whose priesthood boosted her image and the social status of the family. Now, the issue of homosexuality is important to raise because traditionalist Catholics are basically saying that this whole tragedy is due to homosexuality and the solution is to get rid of all gay priests. Now, Catholic moral theology has always insisted that homosexual behaviour is intrinsically disordered, based on scripture and on natural law theory, that says that human sexuality is principally about penetration and procreation. There's no biblical evidence to support that. Where it's condemned in the Bible, it's generally about gay prostitution, particularly in temples. And of course, the issue of homosexual behaviour was developed over centuries well before the emergence of concepts such as sexual orientation, sexual preference, and same-sex attraction. And the traditional Catholic tradition was not complemented by a relational ethic. And it comprehensively rejects the experience of gay people. Now the Church has increasingly accepted the presence of conscientious gay people. But the official Catholic position is still that all gay people have to live lives of enforced celibacy without sexual expression through the virtues of self-control and self-mastery. The final report of the Australian Royal Commission stressed that current Vatican documents that link homosexuality to child sex abuse by clerics are not in keeping with current understandings about healthy human sexuality. And this report and every other report trenchantly insists that homosexuality is not the cause of the sexual abuse of children. There are many well-integrated and mature gay priests who do not abuse children. Let us now go on and talk about and try and enter into the mind of the perpetrator. And this is difficult for us. We find that the offending, that the thinking of the offenders was much more distorted than those of the non-offending priests and brothers. And as well, their mechanisms of denial and their techniques of neutralizing and ensuring the silence of the child victims had a religious overlay. Now, with the normal, if that's the right word, child sex offender, their cognitive distortions say, oh, well, having sex with children is a good way for adults to teach them about sex. But with religious offenders, there's another layer, which is driven by psychospiritual and theological factors, and by the offender's willful, deliberate suspension of their own moral standards. So these rationalizations were, when God called me, He knew what I was like, what my needs were. I have a right to love and affection because I spend my life doing good for others. And God will look after this particular child and see that it comes to no harm. It will have its special protection. Now, these distortions, we find from the two best studies that the offenders blamed their behaviour on things like alcoholism, mental health problems, their parents, their need for intimacy, their sexual orientation. And so their denial leads to more denial. Now, I want to give an example from a Queensland report, which is an example of the gross misuse of spiritual power. And this is a young victim speaking. And this is what he said. Father told me it wasn't a sin, as I was one of God's chosen children, and that God made boys to be special, so that those who did God's work were not led into the temptation of sinning with women. I was told by him that I was to say nothing to anyone, because God would be very angry with me for revealing his secret ways. The second factor...
On that sobering note, you then go on to talk about access to children and that situational opportunity that permits that to occur.
Yes, as part of this jigsaw. There's a fairly direct correlation between religious offending and access to children, because there are some religious orders that have no access to children, and the rate of offending's nil or extremely low. But the unfortunate reality is that access to children, particularly vulnerable children, has grown immensely over the last 2 centuries in particular. One was the growth in educational opportunities for children, the massification of education for children, and that led to the founding of many male and female teaching religious orders. It led to the formation of the Catholic schooling system, which is quite extensive in many countries. But I do want to say publicly at this point in time that certainly in Australia and I'm sure it's true also in New Zealand, that Catholic schools are now very safe institutions because they have brought in proper protocols, and secondly, they are staffed by almost 100% by lay men and lay women. Alongside this schooling expansion was the development of residential schools, and I think we've talked enough about that. We know from the Dutch study that there were many orphan children after World War II, in fact during World War II, and the Dutch bishops were aware of this issue in the 1940s. And then there was a point about some countries introducing a foster care strategy. The John Jay report says that 40% of the abuse occurred in the priest's residence. In the residential care, often the offender's bedroom was next to the dormitory of the children. And so the child would be dragged into that bedroom, often as a punishment for something the child may have done during the day. The other thing was the child migration program, which I've already mentioned. And according to the current UK inquiry, only 549 children were sent to New Zealand, although I'm not totally convinced of that figure. Just over 6,000 were sent to Australia. It was a well-intentioned but badly monitored program, and the British government knew its flaws in the 1950s.
And then you talk about the flawed response of the bishops and other religious leaders to the findings of sexual abuse or complaints of sexual abuse.
Thank you, Madam Counsel. One thing that strikes anyone who looks systematically at this is the startling uniformity of the response of the Catholic bishops in every country. And any report, including the Australian Royal Commission, have heavily criticised the Catholic bishops, their failures, their deliberate attempts to cover up the abuse, which is all embedded in the secrecy and secretiveness at the heart of Catholic governance. And little has changed. And during the 20th century, more and more secrecy provisions were imposed, beginning with the secret of the Holy Office in 1922, and later the pontifical secret. Because with the development during the 20th century of radio transmissions, newspapers, television, investigative journalism, now the social media and so on, the Holy See became increasingly fearful of public scandal, because it and the diocesan bishops were all fearful of scandalising the Catholic faithful. And so they covered up to protect the image of the Catholic Church as an all-holy institution. But all religious leaders do that. The Holy See was always concerned about the accused priest and religious would not receive a fair trial, fair civil trial. But the Vatican showed no concern whatever for the victims of the accused priests and their families. And they used veiled speech and mental reservations. And we go into that in some detail in our longer presentation. But bishops even kept his priest consulters in the dark about why he wanted to shift this particular priest or religious brother to another parish, to another diocese, overseas, or whatever. All in the good name of protecting the reputation of the priest. Now, we've called that, using a social psychologist, Albert Bandura, who is trying to understand why it is that good men do bad things, and why much destructive behaviour has been perpetrated by people such as bishops, and he was looking at the Vietnam War, and how that's been done in the name of righteous ideologies, religious principles, and nationalist frameworks. And we go into some detail about that, and about how that process operates through very questionable moral justification, exonerating social comparisons, and using euphemistic labels. The priest is, the offending priest is having health problems. Other phrases like that. And so that meant that the Holy See officials, the diocesan priests, the leaders of religious orders could minimize their role in causing harm to the victims and their families through the diffusion and displacement of responsibility. And as Bandura states, the triumph of evil requires a lot of good people doing a bit of it in a morally disengaged way, with indifference to the human suffering they have collectively caused.
Thank you, Professor Cahill. Chair, that might be an to give our witness voice a rest, but also to take the break so that the survivors can attend.
And we've reached a convenient point on page 16 of the brief. I think we'd all agree this is a suitable time to take the luncheon adjournment. Madam Registrar, would you please adjourn the sitting?
Professor Cahill, prior to the lunch break, you were just about to move on to the next section, which was the cultural and praxis factors, and that's on page 13 of your brief.
All right, thank you very much, Madam Counsel. We're on to the fourth of the five factors, and Peter will deal with the fifth. It's necessary to understand the cultural and praxis factors operating in an institution. And the Australian Royal Commission listed the following cultural risk factors in institutions caring for children, whether they're schools or orphanages or whatever residential care institutions, whether they're government-based or state-based. Firstly, a lack of understanding or awareness of child sexual abuse or its possibility. Secondly, failure to listen attentively and sensitively to children, especially when they are attempting to disclose. Failure to educate children about healthy and appropriate sexual development. The prioritisation of institutional reputation over the safety of children and the harm done to them. Cultivation of a culture of secrecy and isolation. Failure to see prevention of child sexual abuse as a shared responsibility for all staff. Failure to address racism and prejudice in an institutional culture. And lastly, normalisation of harmful practices. From the Australian report, we know that for the Anglicans, the problems were in the Church of England Boys' Society and in their secondary schools, particularly boarding schools. And for the Anglicans, the Royal Commission said that their risk factors included weaknesses in structure and governance, preventing a consistent response, the role of the bishops and failures of leadership, conflicts of interest for bishops and other office holders, cultural issues including forms of clericalism, the practice of forgiveness and confession, and lastly, inadequate screening, selection, training and supervision of people in ministry. For the Catholic Church, the contributing factors were the individual pathology factors that I mentioned this morning, clericalism in all its facets, and we'll come to that, the monarchical and feudal aspects of governance, including lack of transparency and accountability of those in leadership, and the lack of any meaningful participation of the laity, especially women. Lack of leadership, including poor education for leadership, the failure of canon law and its secrecy provisions, the poor selection, screening and inadequate initial formation of priests, celibacy and the associated sexual dysfunction as the linchpin of the clerical system, the lack of oversight, support and ongoing training of priests and religious, and lastly, the practice of the sacrament of confession and its cheap forgiveness, which allowed perpetrators to minimise the impacts of their sexual abusing. The Salvation Army was criticised for the questionable environment of its residential institutions with poor resourcing, the hierarchical leadership, the devaluing of children, and its type of muscular Christianity. The Jehovah's Witnesses were criticised for the absence of women from their decision-making processes, their separateness from the world, and their two-witness rule, which maintains a person can only be sanctioned if the sexual abuse has been observed by two witnesses. This is based on Deuteronomy 19:15. As we look at the report, I think it should have given more attention to whistleblowing. It showed not much interest in restorative justice, which is not strong in Australia, and a failure to advocate for a healing strategy. And an organisation called For the Innocent Support has produced a healing strategy for the, it's directed at the Catholic Church, and its 22 strategies incorporate a lot of things from the Royal Commission's recommendations, but it would envisage the appointment of chaplains for survivors, gardens of healing, particularly in hotspot parishes where much abuse took place, and contritional Eucharists.
Just before you move on, are you able to confirm what the status of the healing strategy is at this point in time?
It has no status. It's been sent to every Catholic bishop twice now. We get responses from a handful. To what extent they're implementing it varies, I think, across Australia. Because the response is more diocesan-based than nationally based, although now you do have a Catholic professional standards body, but that's focused on redress. Madam Councillor, I'd like now to move on to looking at secretive celibacy, clericalism, the culture of secretive clericalism. And the term is often used, and everyone says it's bad, but it's not always defined. But the Australian Royal Commission called upon, I think, the world's foremost expert in clerical sex abuse, Dr. Thomas Doyle, who was mentioned this morning, a Dominican priest and canon lawyer who was working in the papal nuncio's office in 1984 in Washington. And he noticed all these cases coming across his desk, and he wrote a report that went to Pope John Paul II, and nothing happened. And so that led. So he's identified the following elements of the culture of clericalism. The vocational belief that all priests are unique and special because of the supernatural effects of priestly ordination, and that links up with the idea that a priest upon ordination is ontologically changed. And that's a very questionable theological concept. Secondly, consciousness of a special bond of solidarity that exists among all priests and bishops because of the sacred nature of ordination. Priestly authority which is derived from their role as sacramental ministers, and not necessarily connected to their office as priests. The public perception of priests as men set apart and entitled to deference because of their special calling, and they're entitled to respect and credibility because of their priesthood, not because of their personal competences. Life as celibates in a homosocial environment where they may interact with women and married people, but their essential living environment is all male with no truly intimate relationships allowed. Priests are part of a monarchical culture that is hierarchically stratified and which creates a clerical aristocracy. Priests have a high degree of discretion in their behaviour and a very low degree of supervision and accountability. And priests' official dress, which sets them apart, and when exercising their official ministry at Mass and other sacramental celebrations, they are the central focus of rituals that are generally medieval in nature. Now, the Royal Commission then went on and talked about similar things, and I won't go through these in the interest of time, and you'll appreciate that. But I just want to focus on a few things. One is they bring forward the concept from centuries-old theology of the church as a societas perfecta, a perfect society, and how damaging that was in the development of the theology of priesthood and the hierarchy. The other point I want to point out is also the obligation of mandatory celibacy for Latin Rite priests. In the very complex Catholic Church, you have 23 Eastern Catholic churches, like the Ukrainians, the Maronites, the Melkites. And we know from the Canadian and American data that in these Eastern churches where priests are allowed to marry, because there's always been married priests in the Catholic Church, but not in the Latin Rite. In those Eastern Catholic churches, there was virtually no offending. No offending. And so the Commission found that compulsory celibacy was a contributing factor, but not the cause. So I think we'll now go on to the next part, and that's time for Peter.
Dr. Wilkinson, thank you. And you're going to be speaking to the Commission about the pre-service and in-service training aspects.
Thanks, Ms. James. This Royal Commission is looking at historical sexual abuse, and the Australian Royal Commission found that most of this historical abuse occurred in the period of the 1950s through to the 1980s. So in order to give you a better understanding of the formation program, what I'm going to talk about most is the formation program for priests being formed in the period prior to that, or in the period during the time when the abuse was mostly taking place. I'll say a few words about the programs, current programs, but the essential focus will be on the formation programs for the priests who were abusing in that historic period. The literature on the screening of candidates for the priesthood and religious life, and I'm making the distinction there between the priesthood, the diocesan priesthood, and the religious priesthood. So that's the priests working in dioceses that are incarnated into a diocese that don't take the vows of poverty and chastity and obedience, but they do make a promise of celibacy. Whereas the religious priests and religious brothers and sisters, they take a vow of poverty, a vow of chastity, and a vow of obedience. So, but I'll talk about both of them in the same breath, as it were.
Peter, can I just ask you to slow down a little bit?
Yes, thank you. Thank you.
Thank you.
The literature concludes that the screening processes for young people, and we're talking essentially about young people, wishing to enter a seminary or a novitiate or a juniorate, those processes were inadequate and often defective. The 1917 Code of Canon Law, this is a code of church law, and this is the first code for the Latin Church, was put together in 1917. And in that code there are canons that specifically talk about who should be selected and how they should be formed. Now, Canon 1354 says that bishops should recruit adolescents for training for the clerical state, that's for the priesthood, and that they should establish two kinds of seminaries, a minor seminary for younger boys and a major seminary for older boys. Now, in Australia we had just one minor seminary, and I understand that in New Zealand you also had one minor seminary in Christchurch. The Code's screening requirements were focused mainly on the candidate's legitimacy of birth, prior reception of the sacraments, that is, baptism and confirmation, and known adolescent life and morals. And the prevailing policy was to recruit young boys and girls, if they were going to be religious sisters, showing signs of what was usually called a vocation, and to recruit them as early as possible, before they were humanly and sexually mature, and to admit them to a seminary or a religious juniorate or a novitiate to, I quote, protect them from the contagion of the world. And that's Canon 1353. Now, this policy continued the policy that was adopted by the Council of Trent in the mid-16th century, which specifically called for young boys from the age of 11 to 12 years, preferably young poor boys, to be trained in piety and religion, quote, before habits of vice took possession of them, unquote. At such a young age, proper screening is now impossible. So the real screening was assigned to the seminary or the novitiate formators, who, as time passed, and we're talking about considerable time, years, were expected to dismiss, quote, the disruptive, the incorrigible and unruly candidates, candidates whose lifestyle and characteristics seemed unsuitable for the ecclesiastical state, those not progressing well in their studies or likely to, and above all, those who offend against good morals and faith, unquote. Now, many of the 27 Australian and international reports that we studied in our review on child sexual abuse expressed serious misgivings about the screening processes, as well as the use of personality tests, which, while they might identify certain personality defects, could not provide a fully accurate assessment of a young candidate's capacity for chaste and celibate living. Once admitted to the seminary or the religious house of formation, the candidates were placed in the hands of priest or religious formators for their spiritual, intellectual and disciplinary formation. And prior to the 1990s, there was no mention of human formation. The formators were meant to be the best people available and professionally trained in their respective fields, particularly philosophy, theology, scripture, canon law, liturgy and spirituality. Sometimes they were not. For priest candidates, the major seminary program lasted for a minimum of 6 years, at the end of which the rector or the superior of the formation house was responsible for advising the bishop on each candidate's suitability for ordination. And occasionally, as Des had mentioned, some bishops did not take that advice and ordained candidates who were unready or unsuitable. Canon law also warned of the danger of accepting seminarians dismissed from other seminaries, and Des has already mentioned that about the recycled seminarians, and some bishops were also lax in this area and did not take the necessary screening precautions, and it created a problem, and that problem was specifically addressed in 1996 with a Holy See instruction, but it appears that it has re-emerged. Instructions have also been issued on screening of candidates with homosexual tendencies in 2005, and guidelines for the use of psychology in seminary admission and formation in 2008. The 2005 document on homosexuality was interpreted by some as suggesting that homosexuality was tied to the sexual abuse of children, and Professor Carla has addressed that in his presentation. In many respects, priests and religious were not well served by the pre-Vatican II formation program. The curriculum was heavily intellectualised and rationalistic, with lectures often given in Latin, and Latin textbooks were also used. The content and teaching methodology was essentially scholastic and favouring the text of the 13th century theologian St. Thomas Aquinas. The principles of competency-based and work-integrated learning were not integrated into seminary teaching and curriculum until recent times, and there was a serious mismatch between competencies and capabilities, particularly in respect of the knowledge, skills and attitudes required by a priest for effective parish ministry. Until the 1970s, Catholic seminaries and religious houses of formation were usually situated in rustic, isolated settings outside urban areas and often cut off from secular culture and the dangers of female interaction. They were segregated, regimented and all celibate places where the regime was obedience to the rule and superiors and conformity to the system. And the rule was essentially based on the rules drawn up by St. Charles Borromeo of Milan in the mid-16th century. Yet they were generally happy places, filled with the natural exuberance of youth, and they were, as one former priest described his seminary, places of innocence and youth infused with a spirit of generosity. And for all their shortcomings, they did produce many good, competent and pastorally minded priests. More serious were the deficiencies in the spiritual and psychological formation for healthy and mature living of a celibate life. Candidates for the priesthood and religious life were also enculturated into a clericalist ethos, and Des has already spoken about that, where priestly and religious holiness was seen as superior to lay holiness. And the 1917 Code of Canon Law stipulated, quote, "Clerics must lead an interior and exterior life holier than that of laity." Canon 124. And the Council of Trent decreed that consecrated virginity was a higher calling than marriage because of the sacrificing of sexual intimacy. Preparation for celibate living, however, was minimal and usually entrusted to priests who lacked special training. Celibacy, as Des has already mentioned, was simply part of the package, and it was presented in terms of sacrifice to a higher ideal of sexual purity in imitation of the celibate Jesus Christ. Serious discussion of sexuality never happened, and its psychological aspects were completely ignored. In the pre-Vatican years, and even for decades after, though much of the formation program was the same in every seminary, because it was a systemic program set down in canon law, each seminary or house of religious formation did its own thing, resulting in much duplication, fewer resources because many of the seminaries were very small, and poor educational outcomes. It has changed, however, in recent years. Following the Second Vatican Council in 1962 to 65, serious efforts were made to reform, update and contextualise priestly formation. So between 1965 and 2019, over 40 official documents addressing priestly formation were issued by the Holy See. The most notable being Pope John Paul II's apostolic exhortation on priestly formation in the present circumstances. The Latin name of the document is Pastores Daba Vobis. The other documents were the Fundamental Program for Priestly Formation, first published in 1970 and revised in 2016, and the Directory on the Ministry and Life of Priests, first published in 1994 and revised in 2013. These documents have been augmented by others developed by local episcopal conferences to ensure that the fundamental program with its key principles is suitably adapted to the local social, religious and cultural context of the particular country, such as Australia or New Zealand, where the program is used. In Australia, the national program for priestly formation was developed by the Australian Catholic Bishop Conference in 2007 and revised in 2016. The New Zealand Catholic Bishop Conference have produced a similar document, which I understand has recently been sent to the Holy See for approval. It includes a ratio studiorum, a curriculum if you like, and follows the emphasis on priestly identity and formation for priesthood from the perspectives of human, spiritual, intellectual and pastoral formation. One must assume that the document, which I haven't seen, properly addresses the contemporary issues that challenges priests in New Zealand and which challenge their ministry.
Dr. Wilkinson, can I intervene to ask you to just slow down a little? Yes. So that the signers,
thank you,
as well as the stenotyper, can keep pace with you.
Thank you, Mr. Chair. I would also assume that the prevention of child sexual abuse would have to be included in that national program as a challenge to be included. If I may talk now about the source of priests.
Thank you.
During the 19th and early 20th century, the churches in both Australia and New Zealand relied heavily on priests and religious, brothers and sisters, imported from churches outside both of those countries, mainly from Ireland and from European countries. In the last 2 decades, certainly in Australia, that reliance on priests and religious from overseas has re-emerged, except now it is mainly Asian churches that are supplying the needed priests and religious for the needs of both Australia and New Zealand. In Australia, local seminaries and locally born seminarians did not appear in significant numbers until the 1930s. At that time there were just 7 seminaries, and then in 1940 there were 30, in 1960 there were 39, and in the 1970s they peaked at 43 seminaries and houses of formation. Seminarians, both diocesan and religious, numbered just 200 during the 1920s, rose to 622 in 1940, and peaked at almost 1,400 in the mid-1960s. Since 1970, the number of seminaries has decreased from 43 to 15, and seminarian numbers has fallen from 1,400 to just 302 at the end of 2017. Moreover, at the end of 2017, more than half of all the diocesan seminarians were born outside Australia, mostly in Vietnam, Philippines, and several African nations, and an even greater proportion of religious seminarians are from overseas. In New Zealand, the data shows that there were 4 seminaries in the 1950s, and that from a low base in the 1940s, seminarian numbers, both diocesan and religious, grew rapidly to peak at 335 in 1954. Currently there are just 2 seminaries remaining and a total of 26 seminarians, 21 diocesan and 5 religious.
And just to confirm, that is a change in the numbers from what's in the document by 1.
Oh, thank you.
Thank you, Dr. Wilkinson. Professor Cahill, you've identified that there has been a decline in sexual abuse since the 1980s and outlined 10 reasons for that. Can you summarise those now, please?
Thank you. It has declined, but I want to insist that offences are still being committed, as we shall see. But the reasons for the decline are, I think, the high and sustained public visibility given to the issue since the 1980s, particularly through the media attention. This has been a mitigating impact. The better child protection mechanisms now in place, including through state legislation, the greater vigilance of Catholic parents and church employees, the declining number of active priests over the past 4 decades, and the associated ageing of the remaining group, the dismissal of many at-risk priests and religious brothers, the almost total collapse of the altar boy system, substantial decline in the number of Catholics who regularly make a confession, the closure of the majority of Catholic boarding schools, farming schools, orphanages and other residential institutions, the reduced interaction of students with Catholic priests in Catholic schools, which have become much more professionalised, as I was saying earlier, and more run by lay people, and the partial reform of the selection processes that Peter has been talking about. The Catholic Church has only, in Australia, it's only belatedly followed Catholic churches in other comparative countries by putting in place safeguarding mechanisms in every parish and by setting up better monitoring and training mechanisms, or by establishing special initiatives such as hotlines and helplines as in Germany. We'll come back a little later on to the precautions that have been put in place in the Ireland, the UK and the US. Now I would like to move on to, if I may, to providing transformed care in faith-based institutions and the recommendations of the Australian Royal Commission. And I'll skip over a lot of the detail, but I want to emphasise the points which I see as important. The Australian Royal Commission made 58 recommendations pertaining to religious institutions. And this has all happened within the establishment of the National Office of Child Safety, which from last year was placed in the Department of Prime Minister and Cabinet. It recommended that all religious bodies, with all their institutions, should adopt the 10 child safe standards and work closely with state and territory oversight bodies. And so those religious agencies will have to report their compliance to the National Office, as well as to the religious institution itself, and that all religious leaders must be provided with leadership training in child safety and for mechanisms in place for regularly receiving additional professional expertise. And they need to be accountable to an appropriate authority, as well as a provision for managing conflicts of interest. Any institution with children in its care should be provided with age-appropriate prevention education for the children, including about the power and status issue. And family and community should be involved in commenting and evaluating child safety policies. They further went on and looked at all candidates for religious ministry. They should have an external psychological testing, not in-house, and have undergone training that equips them with the understanding of the 10 standards and about ethical and boundary issues and how to work with children and understanding the impact of child sexual abuse. And that all people in ministry should have effective management and oversight with regular appraisals and with independent professional supervision. They particularly focused on the point that Peter was making about priests coming from overseas and seminarians coming from overseas to work in religious ministry. And there's about 2,000 of those who come into Australia each year for all religious communities. And that they should need to be properly screened, trained, and professionally supervised, and undergo regular training. Another point they made about sacramental confession, which is basically pertains to the Catholic, Orthodox and Anglican churches, that if a child is making a confession, it should be done in an open space with a clear line of sight from another adult, as well as the priest hearing the confession. There are other recommendations about handling of complaint and removal from ministry, including permanent removal from ministry of anyone who's convicted. And then recommendation 1657 deals with the situation where a person, a religious person or a lay person, has been convicted of child sex abuse, has been released from jail if jailed, and then comes back in a normal way with the particular parish or local community, and how there needs to be a risk management plan put in place for such people, and that there should be a national register for each religious organisations. 5 recommendations applied particularly to the Anglican Church regarding a uniform Episcopal standards framework that ensures the accountability of bishops to an appropriate authority. In other words, they can't be king of their own castle. The management of actual or perceived conflicts of interest, the amending of a code of conduct for lay people to incorporate offending against children. And the Church should adopt a national approach to the selection, screening and training of ordination candidates, and ensure that all in pastoral ministry undergo mandatory regular professional development, mandatory professional supervision and regular performance appraisals. The Australian data highlighted that child sex abuse and its mishandling by the Jehovah's Witnesses elders, which included some family abuse cases, was a serious problem. And this has been confirmed in a recent UK study done by the Independent Inquiry over there, where in a study 11% of all victims of religious perpetrators belong to the Jehovah's Witness faith. The Australian Royal Commission recommended they abandon their 2-witness rule in such cases, involve women in assessing allegations, and no longer require its members to shun those who have basically been whistleblowers. The Royal Commission conducted one case study of Jewish yeshiva congregations, making one recommendation that all religious institutions should ensure that their complaint handling policies explicitly state that the halakhic concepts of Mezira, Moza and Lashon Horo do not apply to the communication and reporting of allegations of child sexual abuse to police and other civil authorities. There were 21 recommendations in respect of the Catholic Church. 8 of those were to do with technicalities with regard to common law, and I won't go into the detail, except to mention that one is asking the Vatican authorities to redefine a minor from someone aged from 14 and under to someone aged 18 and under. The Catholic Church still allows girls of 14 and boys of 16 to enter into a marriage if their parents approve. And this is an issue about the age of marriage and child marriage, which is an issue especially in the developing world. Another major recommendation was for the Australian Catholic Church to conduct a national review of governance and management, and that has now commenced, and we're impressed by its membership. The Commission expressed concern about the quality of bishops and their decision-making capacity. So it's asked the Australian Catholic bishops to request the Holy See to publish its criteria for the selection of bishops and establish a transparent appointment process. Nothing has happened. We've heard no word of that. The Royal Commission came to the conclusion that mandatory celibacy was a contributing factor, and it requested the bishops to allow voluntary celibacy for diocesan priests. There was also a series of recommendations about guideline documents and current models of initial formation. I now would like to move on to Catholic safeguarding initiatives.
Just before you do that, for anyone who is interested in reviewing all of the recommendations, can you confirm that the 17 volumes of the Australian Royal Commission are available online, and those specific relating to religious institutions are also there?
Yes, they're all there.
Thank you. We will move now on to safeguarding.
Yes. In our review across the countries outside Australia, I think the three models of safeguarding that this Royal Commission ought to look at is the Irish, the UK and the USA, and there's more detail in our document. But I particularly want to focus on Ireland because that's the model for the Australian one, and in many ways it's a very good one, but there are other ones, but that's the one I'll focus on. The Catholic bishops in Ireland, which covers the Republic and Northern Ireland, established a national board for safeguarding children in the Catholic Church, and its website is there, and you can follow all this if you wish. They established the Towards Healing process, a counselling and support service, and one principal focus has been on the auditing of dioceses and religious orders which are published on the website. By September 2015, it had completed 43 such audits, and it's now begun this year another round of audits. And an interesting new initiative was to provide training in good child safeguarding practices for those Irish missionary priests and volunteers who are going to work in overseas countries in Africa and Asia, for example. Its 2018 annual report notes that it received 143 new notifications against priests and religious, which were mainly of a historic nature. It receives thousands of calls on its helpline and provides face-to-face counselling. And its advocacy service has dealt with many different matters, including connecting clients to services, financial, homelessness, and educational services. And some of its clients are engaged in restorative justice processes. It meets regularly with the Irish police and the government child and family agencies, and provides training for clergy, current trainers and volunteers. And it's done 2 reviews also of its services. In the UK, they have the National Catholic Safeguarding Commission. It's there on its website. In every parish, the UK has a safeguarding representative. Every parish. Its 2018 annual report revealed that in 2017 there are 152 new allegations, and that is increasing, although almost all of them are of a historic nature. The US, which is obviously much bigger, its Secretariat of Child and Youth Protection, you can find it on the United States Catholic Conference of Bishops. It's a bit hard to find, but it puts out a annual report, and last year in its June 2019 report, there had been a sharp rise in allegations, 858. These were mostly historical, but there were 26 allegations made by those who are still today minors, and 7 had been unsubstantiated. So I think there's a lot of material in those on those websites.
Thank you, Professor Cahill. Dr. Wilkinson, turning to you in the microphone. There are now a matter of some special interest topics that you will address and summarise, please.
Thanks, Ms. Jones. I'd like to talk about mandatory reporting and the seal of confession. Des has already pointed out that the occurrence of child sexual abuse by clergy and religious and laypersons has been present in the Catholic Church since early times. It has always been condemned, has always involved power and the abuse of power. It has usually been denied and kept secret, and in recent times has been viewed as a sin, not a crime. During the 20th century, there was substantial criminal child sexual abuse in the Catholic Church in many countries, perpetrated by Catholic priests and members of Catholic religious orders. The Holy See, could I just explain the Holy See? The Holy See in Catholic legal terms means the Pope and the various bureaucracies and ministries, as called dicasteries, that serve the Pope in the work that he does. So I'd use that term, the Holy See. If I refer to the Pope, that'll mean specifically the Pope. So the Holy See, the highest authority in the Church, knew about the abuse during the 20th century and developed a range of legal instruments, including the 1917 and the revised 1983 Code of Canon Law, to construct a wall of secrecy around the abuse, both past and present, on the pretext that the Church faithful needed to be protected from grave scandal and grave offence, and that souls must not be harmed. What the Irish and Victorian parliamentary inquiries found, however, was that the whole legal construct was designed essentially to keep the handling of the abuse in-house and to secure a systemic cover-up on an international scale in order to protect the reputation of the Church and to prevent perpetrators being held accountable. rather than identifying and addressing the problem openly and accountably, looking for the causes of the abuse and seeking to eradicate them, the systemic cover-up arrangements ensured that local communities were kept uninformed of the abuse that had happened and was still happening, allowed the perpetrators not to be held accountable, and contributed to, even facilitated, more abuse. And this happened particularly with the movement of known abusers from one parish where the situation became too hot and the priest was moved to another parish or to overseas or to another diocese. The arrangements were found to be derived from dysfunctional governance, a culture of secrecy and clericalism, and Des has already spoken about that. In the Church's effort to protect its own reputation, it often either entirely overlooked or gave scant consideration to the welfare of the abused children, the effect of the abuse on them and their families, as well as their just entitlement to counselling, compensation and redress. As public awareness of these horrific crimes committed by clergy and religious became widespread, essentially through the media, various responses from the Holy See emerged. One was a special indult granted for the Statute of Limitations. It was extended to 10 years, and the age of minors extended up to 18 years, first in the US in 1994, then in Ireland in 1996, and everywhere in 2001. In 2002, a special limited dispensation from the pontifical secret was granted to the United States to allow the reporting of abuse allegations to civil authorities, but only in states with civil mandatory reporting laws. In 2010, a document entitled A Guide to Understanding Basic CDF. CDF is the congregation, one of the Holy See congregations. It's called the Congregation for the Doctrine and the Faith, usually referred to as CDF. An understanding of their procedures concerning child sexual abuse allegations. And that guide stated, I quote, "Civil law concerning reporting of crimes to the appropriate authorities should always be followed," unquote. So for the first time and worldwide, the Holy See was instructing that wherever civil jurisdictions had reporting laws for child sexual abuse, allegations were to be reported. I'd just like to say something about the duty of care. So before talking about mandatory reporting, let me say that a duty of care is a well-defined legal duty placed on institutions to take reasonable steps to prevent and minimise the risk of child abuse within their organisations. It also gives abuse survivors a clear cause of action to commence legal action against an institution for the abuse that they have suffered, even with the institution having to prove, or with the institution having to prove that it did take reasonable steps to produce the abuse. The Victorian Parliamentary Report, Betrayal of Trust, found that in the state of Victoria, offenders in institutions often obtain credibility trustworthiness and easy access to children in the institution, with the abuse facilitated by the trust relationship. But the liability for the abuse was often unclear and limited. So the parliamentary inquiry recommended a clear legal obligation for the institution to implement appropriate measures to ensure the safety of children in their care, with the institution liable for the abuse by any person associated with the institution. So where a child is found to have been abused, the institution, including a religious institution, is presumed to have breached its duty of care. Mandatory reporting. In the Victorian Parliamentary Inquiry, there was a distinction made between two types of mandatory reporting. The first was mandatory welfare reporting to the child protection authorities. And the other is mandatory criminal reporting, the reporting of a crime or credible evidence of a crime to police. Welfare reporting is for the protection of a child at risk. Criminal reporting is aimed at catching, prosecuting and convicting offenders. It is meant to prevent the concealment of child sexual abuses. Child sexual abuse is a crime, or perhaps we should say is above all a crime, as well as a welfare issue. The Catholic Church in Victoria was initially opposed to the extension of mandatory welfare reporting laws to religious personnel, but later accepted it. But it did not want mandatory criminal reporting and has consistently sought to retain the exemption for information received during the religious rite of confession. The Catholic Archdiocese of Sydney, however, has stated sexual abuse is a crime which must be reported to the police. The best way to investigate it is to report criminal conduct to the police. But in Australia prior to 2015, New South Wales, of which Sydney is the capital, was the only Australian jurisdiction with a civil criminal reporting law. In its evidence to the Victorian Parliamentary Inquiry, the Victoria Police stated that mandatory criminal reporting creates, quote, a public duty to report such suspicions and send a message to everyone with the organisation who may know such issues but are reluctant to become involved, unquote. The seriousness of criminal child sex abusing cannot be denied. The Victorian inquiry concluded that, quote, it should be a crime for any person who knows or believes that a serious offence has been committed by another person against a child and has information that they believe might be of material assistance. It believes that it should be a crime to fail to report that information to police, unquote. The Australian Royal Commission came to the same conclusion about the need for a failure to report offence. But it came to a different conclusion regarding an exemption for information gained in a sacramental confession. Let me talk about mandatory reporting and the seal of confession. The Australian Royal Commission examined both mandatory reporting and the seal of confession. Its criminal justice report recommended the introduction of a failure to report offence. That was recommendation 33, and it's in final report, volume 7, in respect of improving institutional responding and reporting recommendations, made 6 recommendations. Recommendations 7.1 to 7.6 on mandatory reporting.
Excuse me, Peter,
Yes.
can you just slow down?
Certainly, yes. Including 2 recommendations, 7.3 and 7.4, on religious confession. A practice used especially by the Anglican, Catholic and Orthodox churches. Recommendation 7.3 reads, state and territory governments should amend laws concerning mandatory reporting to child protection authorities to achieve national consistency in reporter groups. At a minimum, they should also include the following groups of individuals as mandatory reporters in every jurisdiction. Then it listed the groups, and at Group E was people in religious ministry. Recommendation 7.4 reads, laws concerning mandatory reporting to child protection authorities should not exempt persons in religious ministry from being required to report knowledge or suspicions formed in whole or in part on the basis of information disclosed in or in connection with a religious confession. During the public hearings for case study 50, and that case study was Institutional Review of Catholic Church Authorities, held on the 6th to the 24th of February 2017, the evidence given by the Catholic bishops and canon lawyers, all the archbishops of the Church in Australia gave evidence at that hearing, as well as several leading canon lawyers. They discussed the seal of confession, and the responses of the bishops amongst themselves was confused, and the responses of the bishops and the canon lawyers also did not line up. And it was over 2 issues. One was the confession of a child who had been abused. I forget the name. The name I think was used as Sally. Sally goes to confession and says, "Bless me, Father, I have sinned. I have been abused by a priest." The legal question was, is that Sally's sin that she is confessing? No, it's not her sin, but is that information that Sally has given in her confession information that is covered by the seal of confession? And there was confusion amongst the lawyers and the bishops about whether that was covered. The other question was, if a priest offender comes to you in confession and confesses that he has abused a child, what are your options? In canon law, the confessor can forgive, that's give absolution, he can deny absolution, or he can defer absolution. The question arose is it possible for the confessor to make absolution conditional upon the offender reporting his crime of child sexual abuse to the police. That wasn't able to be resolved at the hearing because of the confused responses of the lawyers and the bishops. So the Australian Royal Commission made recommendation 16.26, and it reads, "The Australian Catholic Bishops' Conference should consult the Holy See and make public any advice received in order to clarify whether A, information received from a child during the sacrament of reconciliation, that's confession, that they have been sexually abused, is covered by the seal of confession. And B, ask the Holy See if a person confesses during the sacrament of reconciliation to perpetrating child sexual abuse, whether absolution can and should be withheld until they report themselves to civil authorities." I made an inquiry of the General Secretary of the Australian Bishops' Conference before coming here to present to this Commission, and I asked what had transpired with regard to these recommendations, the 7.3, 7.4 and specifically 16.26. I was advised that all the recommendations of the Royal Commission had been sent to the Holy See, and that there had been consultation between the Australian Bishops' Conference and the Holy See concerning these specific recommendations. That the consultation is ongoing, and that during the Australian Bishops' visit to Rome, their ad limina bishop in June of this year, further consultation had taken place. I was also advised that on the 29th of June of this year, the Holy See's Apostolic Penitentiary, that's one of the departments of the Holy See, had issued a document titled Note of the Apostolic Penitentiary on the importance of the internal forum and the inviolability of the sacramental seal. It was published on the Vatican website, and it was approved by Pope Francis, and that note is significant for this Royal Commission, for it contains very strict interpretations of the seal of confession, including the following. The sacramental seal is indispensable. No human power has jurisdiction over it, nor can any human power lay claim to it. It is indispensable for the sanctity of the sacrament and for the freedom of conscience of the penitent, who must be certain at any time that the sacramental conversation will remain within the secrecy of the confessional. Second point, the inviolable secrecy comes directly from the revealed divine right. It does not admit of any exception in the ecclesial sphere, nor least of all in the civil one. Point 3. The Church has always taught that priests, in the celebration of the sacraments, acts in the very person of Christ the head. Point 4. The confessor must defend the sacramental seal, if necessary, quote, to the spilling of his own blood, namely martyrdom. Point 5. The seal is regulated by canon law and explained in the Catechism of the Catholic Church, which states that, quote, every priest who hears confessions is bound under very severe penalties to keep absolute secrecy regarding the sins that his penitents have confessed to him, unquote. Point 6. The confessor is never allowed, for any reason whatsoever, quote, to betray in any way a penitent in words or in any manner, unquote. Just as, quote, a confessor is prohibited completely from using knowledge acquired from confession to the detriment of the penitent, even when any danger of revelation is excluded, unquote. Point 7. The sacramental seal includes, quote, all the sins of both the penitent and others known from the penitent's confession, both mortal and venial, both occult and public, as manifested with regard to absolution, and therefore known to the confessor by virtue of sacramental knowledge, unquote. Point 8. The sacramental seal concerns everything the penitent has admitted, even in the event that the confessor does not grant absolution. If the confession is invalid, or for some reason the absolution is not given, the seal must be maintained in any case. Point 9. The priest becomes aware of the sins of the penitent, quote, not as man, but as God, unquote, to such an extent that he simply, quote, does not know, unquote, what he was told during confession, because he did not listen to the penitent as a man, but precisely in the name of God. Point 10. The confessor can therefore, quote, swear, unquote, without any prejudice to his conscience, to, quote, not know, unquote, what he knows only as a minister of God. Point 11. In the presence of sins that involve criminal offences, it is never permissible, as a condition for absolution, to place on the penitent the obligation to turn himself in to civil justice. Where a penitent has been a victim of the evil of others, the confessor must instruct the penitent regarding his rights and the practical juridical instruments to refer to, in order to report the fact in a civil and/or ecclesiastical forum to invoke justice.
Peter, may I just stop you there and check with the Chair? I'm very conscious that we have gone past the adjournment. That would be a convenient point to stop and pick up.
I think this would be a suitable time for the afternoon adjournment to be taken. Madam Registrar?
Thank you, Chair. With the indulgence of the Commission, we're very conscious of the time, and so if we could move very briefly to redress and civil litigation, I foreshadow the comments that this is a summary of the Australian Royal Commission findings, so they are available to the Commission and anyone else who is interested, and we also have the written long brief and summary. So without any disadvantage to the information available to the Commission, Dr. Wilkinson, could I just ask you please to summarise what the Royal Commission found was an appropriate redress framework?
Thank you, Ms Jones.
Page 26.
Yes. In essence, what the Commission insisted were the appropriate redress for survivors who were looking for justice. That the redress should include three elements: direct personal response, counselling and psychological care, and monetary payments. And then that's expounded on in the document you have before you. Yes.
Thank you, Dr. Wilkinson. Turning the microphone now to Professor Cahill. Just emphasising that you're not here speaking about the New Zealand context, but are there recommendations you would like to make to this Royal Commission as it embarks on investigation of this aspect that you would want them to consider?
I think one of the key things that you would need to look at is really prevalence data and trying to collect that, particularly in regard to the Catholic Church. I think the English Nolan inquiry in 2000 was certainly not a failure, but it would have been much strengthened if it had had prevalence data. So that's what I would say. So in conclusion, in concluding our input, I think you're going to have to deal with the issue of the governance and management of religion and religious diversity, especially when you have bad religion or bad religious practices. And connected to that is the whole issue of the right to religious freedom. In 2011, I was a co-author of a study for the Australian Law Reform Commission on this freedom of religion. I think you need to keep in mind that the right to religious freedom is a relative, not an absolute right. And therefore the difficulty is, where do you draw the line? And that's an issue which needs a lot of debate across the world, actually, by legal philosophers, moral theologians, and so on. And lastly, to say, in all of this, let us never forget the child. Children, with their openness, trust and receptiveness, give us a glimpse of openness to God. And we've concluded our presentation with a quote from the Catholic Education Office of South Australia, highlighting the wonder of children. So thank you very much.
And in the absence of the Jehovah's Witnesses have raised some issues about findings of the Royal Commission. These two witnesses are not able to assist with that, but if I may introduce through them an exhibit so that the Commissioners have available the findings of the Australian Royal Commission, but also the independent review about data that looks at those issues so that the Commission may make its own findings on those points. So I produce as Exhibit 17, Jehovah's Witnesses and the final report of the Royal Commission into Institutional Responses to Child Sexual Abuse, 14 November 2018. I'll leave you there. We do have indication from Council that there are two who would like to question Professor Cahill and Dr. Wilkinson? I'll just check if that's still correct. First, Ms. Guy Kidd, QC.
Mr. Kidd, please come forward.
Tēnā koutou, good afternoon. My name is Fiona Guy Kidd, and I appear for the General Synod known as Te Hinota Whanui of the Anglican Church of Aotearoa, New Zealand and Polynesia. And I've just got a few questions arising out of your evidence today. Firstly, on page 14 of your shortened report, the one you've been referring to today, when dealing with the issue of cultural and praxis factors, and am I correct in understanding that praxis is another word for practice? Thank you. You talk about the findings of the Australian Royal Commission, and you speak of the problems for the Anglicans were in the Church of England Boys Society and in their secondary schools. And I'm curious, what is the Church of England Boys Society?
I'm not an expert on the Anglican Church, but as I understand it, it was a society specifically for boys, adolescent boys, to encourage them to remain in the Anglican faith, and also as a kind of youth group. And so it didn't exist in every parish, as I understand it. It was more a diocesan thing. And the problems was partly to do with clergy, but it was more to do with the youth workers that were employed by the church who ended up abusing younger people, younger adolescents.
Thank you. Now, on page 15, and this is a part that you didn't speak to orally, but you write there about the culture of secretive clericalism in the Catholic Church, and you comment there, similar features are found in the Anglican Church. And my question is, are you referring to the Anglican Church in Australia?
That comes from the Royal Commission. So yes, they are referring to the Anglican Church in Australia.
Right.
But evidence, may I draw your attention, because I think that as a result of the introduction of women to ordination and to the episcopacy, there's now a feeling that the level of clericalism is much diminished in the Anglican Church. And I'd like you to draw your attention to the work of Bishop Alison Taylor, who was the fourth woman in Australia to be consecrated as an Anglican bishop for the Diocese of Brisbane. And she is currently doing a PhD on interrogating holiness, a contribution to the ecclesiology of the Anglican Church of Australia in light of the child sex abuse scandal. And she spoke last year at a conference organised by the University of Divinity in Melbourne. And I think she would be a very good source for you in looking at this whole issue from an Anglican perspective, which, as I understand, is complicated by the different traditions within the Anglican Church, the Anglo-Catholic, the Evangelical, and the more liberal progressive.
And so, now that we've identified that's the Anglican Church in Australia and that comes from their recommendations, and you're talking here about cultural and practice factors in relation to this culture of clericalism, would you agree that to determine to the extent that clericalism is active in the Anglican Church in New Zealand, one would need to look at the composition of the people in authority in the church, you're nodding, the rules, governing rules, the gender makeup, and maybe even the ethnic makeup of who's involved in that church. Would that be fair?
I think that's fair, but anything I've said about the Anglican Church in our presentation is taken directly from the Royal Commission report. And, you know, I cannot comment at all with any knowledge about the Anglican Church in New Zealand. May I add also that the Anglican Church in Australia has instituted a new procedure for the sacrament of confession, yes, which does allow for mandatory reporting if a priest comes to knowledge of child sex abuse in the confessional, but I can't give you the detail.
And even within the Anglican Church in Australia, there are some conservative parts in relation to the ordination of women. Yeah. For instance, Sydney, which I understand is the largest diocese of the Anglican Church in Australia, still does not permit the ordination of women, whereas in New Zealand, all parts of our structure encourage the ordination of women. And we led Australia by some 15 years in the ordination of women. So that's another example of a different factor. Thank you for your assistance.
Ms McKechnie.
Good afternoon, Professor Cahill, Dr Wilkinson. Commissioners, we had sought leave to ask questions, but in light of the range of issues raised and the focus on Australia, now doesn't seem the appropriate time to interrogate those. And so while my clients don't necessarily accept all the evidence that has been given and that there is a range of perspectives that you will hear in the future, now is not the time that we will explore those. Thank you.
I now hand the witnesses to the commissioners.
Thank you. I'll now ask my colleagues if any of them has a wish to ask questions of Professor Cahill and Dr Wilkinson. Can I start with you, Mr Gibson?
I think just briefly a clarifying question about timing. The document on the inviolability of the sacrament of confession, that was written after the Australian Royal Commission of Inquiry.
Yes.
And was your sense in response to some of the recommendations of it?
My response to the content of the note?
Yes. The inviolability document was written in response to the Australian inquiry. Is that your sense of?
Oh yes, it was definitely written in response, I think, to those questions that were posed or recommended by the Australian Royal Commission, and referred to Rome for explicit clarification by the relevant authority at the Holy See.
Okay, yep. Thanks.
Ms Salorfi-Vai.
Thank you. Thank you, Dr Wilkinson and Professor Cahill. So, just clarifying, you were referring to the note there?
Yes. When Professor Cahill and I met with the Australian Royal Commissioner, Justice Peter McClelland, one of the things he asked us was, in the recommendations that we're likely to make, what is the appropriate way for our recommendations to reach the Holy See? because canon law is made by the Holy See and specifically by the Pope. So the Pope can change canon law as and when he wishes. And the Royal Commission was aware that it was probably going to need to recommend changes, but it wasn't sure how its recommendations could reach the Holy See. So our response to Justice McClellan was to say the appropriate way would be to make a recommendation to the Australian Catholic Bishops' Conference, and through them the recommendation could then be forwarded to the Holy See for whatever response that you required. And that was the way the Australian Royal Commission worked. So they made the recommendation to the Australian Catholic Bishops' Conference that they should refer this matter to the Holy See for clarification, and subsequent to that, this note, which is only a couple of months old, has been written and is now public and available on the Holy See's, on the Vatican website.
Thank you. So following it, so that note then is, for want of a better phrase, it's your current policy, or it's how is that perceived in terms of influence if it's on the website?
It would be perceived as the current policy of the Holy See. Now, I'm not sure what its status would be as canon law, because it's not formulated as legal decrees. But it is giving an official opinion as to how the seal is now being interpreted by the Holy See, not only in respect to that question about what is covered and is conditionality acceptable, but across a wider range of concerns about what is covered by the seal of confession and how seriously it may be protected, and particularly whether civil law has any not only influence but any effect on the seal.
Okay, thank you. And so appreciating that that would have happened at a high level in terms of the administration.
Highest.
The highest level. If you bring it down a couple of levels, what is the discourse, what was the socialisation of the final recommendations that came out in the note amongst the Australian Catholic public, at least?
I would say at this stage that the Australian Catholic public are not aware of this note. It's not the sort of thing that the media have picked up on as yet. It's not the sort of thing that ordinary Catholics go hunting for. And bear in mind that the practice of sacramental confession in Australia is extremely low. So I think the figure that's normally tossed around is maybe 1% of Catholics go to confession, maybe even lower, because at the moment only 10% of Catholics regularly go to Mass. And the practice of going to sacramental confession is very, very low.
Thank you. And just
Can I just add to that? If the note is a document for the Universal Church, okay? It's not specifically for Australia. And no doubt there may be things that came from other Episcopal conferences. Now, the Australian bishops, for all the recommendations, except for the seal, which they didn't recommend to be followed, they sent all those off to Rome, okay? But we don't know about the supporting documentation with regard to each of the recommendations that was forwarded to Rome and that were relevant to Rome. So I think that's an important point. Secondly, every 5 years, the bishops have to give a quinquennial report on their own diocese prior to their making what's called an ad limina visit to the Pope, where they meet the Pope and the heads of dicasteries. And it's really a stocktake on each particular diocese and the national church. Your bishops here in New Zealand have just finished theirs a week, 2 weeks ago, whereas the Australian one was in June, I think, yes, June. And I think it would be very interesting if the Royal Commission subpoenaed those quinquennial reports, not only about what, in particular this latest one, on the issue of confession, the seal of confession, but also the prevalence data, if they have done any prevalence data within their own diocese, and how truthfully their quinquennial report reflects the real situation in their particular diocese.
The quinquennial report is mandated at Canon 399.1 of the 1983 Code of Canon Law, and each bishop who is in charge of a diocese must submit that report, and there is a form that they must follow. It has 22 sections in it, and section, I think 7, relates to the life and ministry of priests, so they must report on that, and section 8 is to do with religious members of the congregations, and they must report on that. Furthermore, each bishop in the report is urged to be objective, precise and succinct, and must include his pastoral difficulties in the diocese, the causes of those difficulties, the means being used to resolve them, pastoral issues yet to be resolved, and confidential matters which can be sent directly to the relevant congregation. And the bishop's personal contribution is essential. So they are matters that must be in those quinquennial reports. Now, we're not sure where those quinquennial reports go to. I asked the archivist in the Melbourne Archdiocesan Archives, do those reports, are they in the archives? And she said, Peter, there are no reports in the archives, not even in the secret archives. I have found only one, and that seems to be accidental. So I'm not sure what the Australian Royal Commission, whether they tried to get hold of those documents or whether they were unobtainable, but that might be something that you would like to take up with the Attorney General in Australia.
Just one final question. In a lot of our private sessions, a recurring theme or an insight that's coming through is around the concept of celibacy. So I looked at your comments very carefully about what came out of the Australian Royal Commission, and that actually there's evidence to support why canon law should be changed to revisit that.
Yes, and it is local bishops or local episcopal conferences cannot change that law. It is beyond their competence, is the phrase. That is something that only the Pope can change. Now, there is, I don't think you'd call it pressure, but certainly within the Catholic community, within Australia, there are certain quarters that would enthusiastically support the removal of mandatory clerical celibacy. Others would say it must remain, but that is a decision beyond the competency of the Australian Church or the Church in Australia. I should imagine that at the upcoming 2020 plenary council that is to be held in Australia, that issue will be on the agenda.
Thank you. No further questions. Much appreciated.
Thank you. Dr. Edawiti.
Tēnā kōrua. It seems that in Australia, even though there are, and if you could clarify for me, mandatory reporting laws even for confessions made in the confessional across several states. Is that correct?
Yes.
And yet, I saw recently that the Archbishop of Melbourne, that's your hometown, isn't it?
Yes.
Said that he would defy the law. Is that correct?
That, yes.
So there is this deeply entrenched culture of opposition to mandatory reporting in these Australian states.
When a bishop is appointed, he swears, I'm not sure whether an oath, I think it is, to be obedient to the Pope, to maintain the communion within the Catholic Church. Therefore, whatever the official position of the Catholic Church is, a bishop would be expected to observe that position. And therefore, that if there is a mandatory civil law that says he break the seal of confession, then effectively that would break the communion within the church between the bishop and the Pope. Yeah. So I think that is the source of that response.
I mean, it's true that the Archbishop of Melbourne basically said, well, I would go to jail.
Yes.
Okay, that was very clear. Now, here in New Zealand, I suspect that it's a matter of some sensitivity, because during World War II, a New Zealand Columban priest was executed by Japanese soldiers because he refused to give any information about the confessions, they knew that, of guerrillas who were living up in the hills. And they knew that the Japanese soldiers knew about that. That priest's name is Francis Douglas, and I think there is some moves to try and canonize him as a saint, because he is seen as a martyr for defending the seal of confession.
Okay. I mean, it seems even in your paper that you're not insisting that the Church change this principle, but that it rethink it in light of the factors that you outline on page 27 of your paper. Is that right? Yeah. Mm. And in the interest of, because the balance then is freedom of religion.
Well, I think our position is that the child must come first. The safety of the child, we feel, is greater than the sacredness of the seal. And that needs more discussion. And I think that will be something, I think, for you as commissioners that we'll have to look at clearly, because there will be an expectation, I suspect, that you say something about the seal of confession in your final report.
There is a 2,000-year history to this, because initially the Church only had the practice of open confessions made publicly. And then by about the 5th century, it started to change to private confession being heard by the confessor. After the Second Vatican Council, there were other forms of confession that were brought in, particularly a communal penitential or reconciliation session, where the person would confess in private to God, and then absolution would be given to the whole community. Then that was abrogated by Pope John Paul II. So I think there needs to be a conversation that goes on within the Catholic Church at a universal level about whether to go back to that or to even have new forms of confession.
Thank you. Another question is, this is part of the puzzle, it's plainly a man on boy issue here of sexual abuse in the context of the church, and you seem to provide some explanation by referring to psychosexual issues and also location. But at the same time, you would find that you also, I think you said that with nuns, religious nuns, that even though you perhaps should have similar sorts of features of psychosexual and also accessibility, yet it still remains a older male on boy is the prominent feature. Are you able to unpack that for me?
With regard to the priests and religious brothers, or to the nuns?
Well, the comparison is that it's not so prevalent in the context of nuns and children, right? Even though it would seem to me that there would be similar sort of psychosexual aberrations, abnormalities as you describe them, and also access. But it seems to be mostly there is abuse, but it's mostly physical and not sexual. The sexual abuse is largely men, priests, on boys.
Mm. Yeah.
Why is there this distinction, is the question, fundamentally?
I'm not sure I've understood you fully. Don't forget that 30% of the victims were girls, females, okay? And that was partly an access issue, but also of orientation. So, there are many factors coming into this. With regard to the low offending rate among nuns, the Australian Royal Commission figures are 96, and we think that's an exaggeration for various reasons, but it's quite low. But with regard to the sexual abuse by nuns of children, the rate was extremely low, and I suppose you have to explain that in terms of, one is the lack of sexual knowledge of nuns during, up until the 60s and 70s was extremely low, and that comes out in the Queensland Ford report. But also I think that nuns had a better appreciation of their own virginal commitment, and perhaps the level of sexual desire was not as immediate or as strong as it is with priests and brothers.
Sure.
May I thank both of you for your evidence. All of the questions that I had have already been covered by my colleagues, so I won't labour the point. But thank you both very much.
I have one question which relates to, and I'm not going to use the language you used, but the Royal Commission made its findings to the Bishops' Conference on the basis that the bishops would send the request or the finding to the Holy See. Was it ever canvassed that they might simply make the recommendation to the bishops and leave it at that?
Well, the Royal Commissioners were very aware, and they had a deep knowledge of the Catholic Church. They knew that on some of the recommendations, it was only Rome that could make the decision and do the necessary recommended changes. And so that's why the recommendations are worded that way. And so the Australian bishops had no trouble accepting those recommendations because, in a sense, they were acting as a postbox to send it to Rome. What we don't know, and it's never been revealed, is what was the covering letter and the comment by the bishops on each of those recommendations. Did they make no comment? Did they make a negative, put a negative view of the particular recommendation or a positive view? We don't know. It wasn't until 8 months later that the bishops actually came together and made an explicit decision on each of the relevant recommendations. And there's been a lot of criticism that it took them so long to get to that point of making that decision, because there's a lot of division within the Australian Episcopal Conference. And that is part of the problem, that they find it very hard to get cohesion and agreement on almost anything. I think Peter would probably agree with that.
Can I also... the Australian Catholic Bishops' Conference set up a mechanism or a structure called the Truth, Justice and Healing Council that would be the liaison group between the Australian Royal Commission and the Catholic Bishops' Conference. And I understand that the New Zealand Catholic Bishops' Conference has set up a similar structure. I would imagine that before that mechanism that we talked about, namely sending the recommendations through the Catholic Bishops' Conference, that would have been discussed with the Truth, Justice and Healing Council to sound out whether this was a process that was acceptable to the bishops. At no stage that I'm aware of was there any discussion about it being an unsuitable process for getting the recommendations from the Commission to the Holy See.
Thank you for clarifying that. I join my colleagues, gentlemen, in thanking you for the broad expanse of your evidence, which you can be assured will be of great assistance to the Royal Commission. Thank you.
Thank you, Mr. Chair. Thank you, Commissioners.
Thank you, Chair, and thank you, Professor Cahill and Dr. Wilkinson, for your evidence. That is now concluded and you may step down.
Thank you.
Chair and Commissioners, while they're doing that, Ms McKechnie has requested and been given leave to make a short statement.
Ms McKechnie.
Thank you, Chair. Commissioners. Following the close of this hearing, the next focus of the Royal Commission is going to be on the state and the Crown response. And it's going to be some time before Catholic matters come back before the Commission. And because of that, the bishops and congregational leaders have sought and have been granted leave to make some remarks at this point. So thank you for leave. I make these remarks, Commissioners, on behalf of Te Rōpū Tautoko, which, as the witnesses have just mentioned, has been set up by both the bishops and the congregational leaders of the Catholic Church in Aotearoa, New Zealand. At this contextual hearing, there has been evidence which sets the scene for the work that you'll do in the coming months. And today, there has been extensive evidence about Catholic matters. Representatives of Te Rōpū Tautoko and of the Auckland Diocese, as we are here in their diocese, have attended the hearing, each day of the hearing, and listened to the evidence, both state and faith-based, and have learned much from the witnesses. Their presence here, I want to say to you and to those who are listening on the live stream, is part of the commitment by the bishops and congregational leaders of the Catholic Church to listen, to learn from, and to support the survivors. Our clients are very conscious, Commissioners, that there may well be survivors listening to this hearing who have not approached the Catholic entities or the civil authorities about their experiences. And they are encouraged to do that, to approach the National Office of Professional Standards, which represents the Catholic entities here, or to approach the police. And so I say that to those of you who may be listening who have not yet come forward. We also encourage them to approach you and share their experiences with the Royal Commission. Turning to the evidence that this Royal Commission will hear in the future about the Catholic Church and the entities of that church in New Zealand, the Catholic bishops and congregational leaders are very aware that dark chapters of their history will be examined. Some of that evidence has been heard in this hearing already. Sadly, it is very clear that many things have happened within the Catholic dioceses and congregations in New Zealand which should not have happened. All forms of abuse are unacceptable and indefensible, and all people should have been safe in the care of Catholic entities in New Zealand. The bishops and congregational leaders are committed to working with the Royal Commission in this inquiry and have asked me to publicly reiterate that both to you and to those who are listening this afternoon. They are committed to their errors and omissions being examined transparently and openly. They acknowledge that as part of a global church, there have been a significant number of inquiries and investigations into Catholic entities around the world, including, as we've heard extensively today, in Australia. Many of these inquiries have revealed events which should never have happened, and for which the Pope and the Catholic leaders in those areas have expressed great regret. The evidence of Professor Cahill and Dr. Wilkinson at this hearing has discussed some of that context in other countries, and it has sought to draw parallels in New Zealand and make a number of global generalisations about what you may find here. Now, while our clients do not agree with all of the evidence given by Professor Cahill and Dr. Wilkinson, and as you have heard, there is a range of perspectives amongst Catholics and Catholic entities around the world and indeed in New Zealand, they accept and acknowledge that there are very serious issues to consider. There will be parallels which you can draw from the global experience. But because of the size and the structure and the nature of the Catholic community and leadership here in Aotearoa, there are significant differences that will need your exploration. Professor Cahill and Dr. Wilkinson highlighted some of those differences in their evidence this afternoon. The history of care provided by Catholic entities in New Zealand is also complex. As you will hear in evidence in your future inquiries, I am sure, it is a history of both significant societal good and times of intense shame. As you embark on your work, Commissioners, the Catholic bishops and congregational leaders ask that you consider the entities within the Catholic Church in Aotearoa New Zealand in their full context and in the context of Aotearoa New Zealand. Its work, its errors, the lessons they have learned and the lessons that they are still to learn. We anticipate, and Councillor Sisting indicated this morning, that investigations into faith-based churches will begin shortly. We anticipate there will be an investigation into care by Catholic entities here. The Catholic bishops and congregational leaders welcome that opportunity. They're committed to accepting responsibility and their responsibility to act to stop future abuse in the Catholic Church and to learn the lessons of how to respond to what has already happened and should not have happened in the care of the Catholic entities in Aotearoa New Zealand. They're committed to learning the lessons that will come from your work. Thank you.
Mr. Mount.
Mr. Chair, Commissioners, as we draw towards the close of this contextual hearing, may I seek your indulgence to make some closing remarks?
Certainly.
I begin by acknowledging Mana Whenua Ngāti Whātua for generously hosting us, for opening each day and for closing each day. Your support and your welcome are very much appreciated. I also acknowledge survivors and members of our Survivor Advisory Group and our ambassadors who have either joined us here in person or who have watched on the live stream or who have otherwise been involved in this hearing. I also acknowledge the witnesses who have participated and in many cases have very generously shared some of the most important aspects of their lives with us over the last 2 weeks. And I also acknowledge the other participants who have contributed to this hearing, and of course the members of the Secretariat and others who have made this complicated process possible. As you know, this is New Zealand's largest ever Royal Commission, and no doubt there are many different ways in which we could measure size. But what we have seen in the last 2 weeks is that perhaps the most appropriate measure is to say that this is perhaps the largest in terms of the number of people affected and the largest in terms of the impact on New Zealanders who have been abused or neglected in care, as well as their families, their communities, and also the generations over time. We've heard from 29 witnesses in this room, but in many cases they have spoken on behalf of large numbers of others. From Judge Henwood, who spoke on behalf of 1,100 people who came forward to the confidential listening and assistance service, to Sonia Cooper and Amanda Hill, who represented more than 1,000 clients of their firm, and survivors such as Rawiri Waratini Karena and Arthur Taylor, who represented the thousands of people in prison and the generations before them. So if nothing else, it is obvious that this inquiry is a lot bigger than any one person. But, Mr. Chair, we won't see you at another public hearing, and so it is appropriate to acknowledge at this time that you are not only the first among equals at the Commissioner table, but you were also the first to take on the responsibility of this important work. It was early last year when you accepted the request of the government to lead public consultation on the terms of reference for this inquiry. It was the first time that had been done in New Zealand to lead a fully public consultation process for the terms of reference of a Royal Commission. And you brought to that task your mana and the respect in which you are held as our former Governor-General and the holder of several high public offices. And I know that the many people that you met with very much respected and appreciated the way you approached that task. It was then you who recommended to the government that the scope of this inquiry be broadened from state care to include non-state care, particularly faith-based institutions. And importantly, you recommended that Te Tiriti o Waitangi be built in to the terms of reference and woven into the fabric of the Royal Commission. Those were your suggestions, which were accepted by the government, and they form a very important part of the work of the inquiry. Late last year, you were joined by your 4 colleagues, and having helped to design the ship, you have captained it to its first waypoint, the start of the private sessions earlier this year, and now to this significant waypoint, the end of the first substantive contextual public hearing. And if I may say, what you have shown throughout the time since you took on this important work is an uncompromising commitment to the substance of the work, a steady resolve to do the work in a principled, inclusive and sensitive way, and a deep compassion for the New Zealanders of all backgrounds who are at the centre of this work. Very soon you will be passing on the responsibility of captaining the ship to a new chair. And what we have seen, if I may say so, in the last 2 weeks is that this is an inquiry in good health and one with real grassroots support. And for that, Mr. Chair, we thank you. There will, I hope, be other opportunities to thank you and to acknowledge you for what you have done. But I do know that I speak on behalf of a very large number of people in wanting to acknowledge you today on this public occasion. Now, Madam Registrar, I believe that you may have a further exhibit that you may be able to present directly to the Chair. And on that note, for the final time in this public hearing, may it please the Commission, kia ora tātou katoa.
Thank you, Mr. Marr. Ms. McCartney.
I am speaking on behalf of all council. And addressing you, Sir Anand, because we wish to acknowledge your retirement as Chair. In speaking on behalf of all council, all ask me to convey to you our thanks for the mana that you have brought to these hearings. And such was the mana that you have brought that in the 9 days we have been here, we have seen survivors of the abuse, witnesses who have been prepared to speak publicly about their most personal experiences. And of those survivor witnesses, there are survivors who, while they started out in terrible circumstances, they were able to tell us how they went on to get high education degrees. Some of them, having been gang leaders, went on to do this. Another is a United Nations representative. And there were quite a number who had written books. The indictment on New Zealand is that so many of them said there were times when they felt they were not human. And every one of them said that they lost trust in authority. Yet before this Royal Commission, they were able to stand up and speak of their experiences. You, Sir Anand, spoke directly to each one of them. You provided a personal and sincere thanks to each one. You conveyed respect and empowerment. And those who are here of the survivors, they saw that. Your dignified leadership has really set the course of this Royal Commission. If I may turn and just speak to the survivors who are here, as Council, we hope that having seen these last 9 days, that you can be optimistic that this Royal Commission may bring about the transformational change that you are seeking. We, as Council, are optimistic of that. And we wish to convey to the survivors that in the time that you have spoken and the time of these hearings, the hope that we had that many more will come forward has in fact been expressed to us already. We are already hearing that this is happening. Sir Anand, Council appearing here have a great affection for you. It has been a privilege to be here for your final sitting. Ngā mihi mahana.
Ladies and gentlemen, I am going to exercise a right of reply, and I'm conscious as I start of needing to be brief and to say what I ought. In the words of 1 Corinthians 40, that is, decently and in order. I first acknowledge, as I ought, mana whenua Ngāti Whātua o Ōrākei, whose presence has indeed been a central point of reference in the last fortnight. The connection is appropriate for a number of reasons. I have had many associations with Ngāti Whātua, ranging from standing with the late Takutai Doc Wikiriwhi at many public occasions, through seeking and obtaining the help of Kahurangi Naida Glavish on many topics, including how this Royal Commission should work when I was doing the public consultation last year. And lastly, I recall when having the privilege of being Governor-General and the equal privilege of hosting Prince William at Government House in Epsom, the centrepiece was a magnificent hangi put down by the Hawke family. To all of you, greetings. The whakapapa element of my speech is to reflect on a life that has been steeped in the law and the community. All of that has been relevant to the setting up of the Royal Commission. And it's been a real professional thrill to be part of this contextual hearing and to observe the lawyers plying their skills in the course of this hearing. On the basis of doing the right thing, I want at this point, Mr. Mount, to return to you through the registrar the wonderful book called The Conduct of Public Inquiries by Ed Ratushny, which you gave me as we started to work together. It has never been far away from me, at work and at home, and I have made a frequent reference to it. The whaikōrero element of my speech is to reflect that today is Friday, the 8th day of November 2019, the 312th day of our 2019 year. We are just 2 days short of an anniversary of the 10th of November in 1942, which incidentally was a Tuesday. On that day, 77 years ago, in the midst of World War II, in a memorable speech at Mansion House in London, speaking at a crucial turn of events in that war, the Prime Minister of the UK, the Right Honourable Winston Churchill, said, in the context of things that had occurred, "Now this is not the end. It is not even the beginning of the end, but it is perhaps the end of the beginning." That statement about the end of the beginning characterises, to my mind, the positioning today of where we all are in mid-2019 in the life of the Royal Commission into Abuse and Care. We are truly here in New Zealand at the end of another beginning, and the successful completion of this contextual hearing has provided that. A considerable amount to date has been done and spoken about since I started in office as Chair of the Royal Commission, appointed on 1 February 2018, into a role which was to galvanise the purpose of the Royal Commission. Looking at you and acknowledging you makes a number of things clear. As I see you, may I say, in a nutshell, the contribution that everyone has made is made up of a number of little things, all of which point to making two important points. Number one, in a country like New Zealand, we support whatever is the game and its followers. The work of the Royal Commission is important and vital, as a number of the nearly 30 witnesses over these 2 weeks have said in a variety of ways. Number two, in the same setting, we support those people who have put in time and effort to ensure that we have done well. I refer, of course, and principally, to the survivors and their advisors and families. I refer to the academic community, to the media representatives, and the staff that the Royal Commission has amassed, the logistics staff, the wellbeing staff, the people who have made sure that things over a lengthy time have started on time and ended in the same way. Everyone has provided a professional input to make things go as well as they have. This brings me to the wero element and the challenge to the Royal Commission that has been laid down by many witnesses. One is the work which is unique, another is the breadth of what's involved, and another yet is the people who service it. It is inherently difficult for a government department whose natural territory is libraries, raffles and passports to take on the servicing of the largest Royal Commission that the country has known. But the Department of Internal Affairs has us and we have them. Everyone deserves encouragement in what lies ahead, and I offer mine. It has been a privilege to be a central part of the build-up and delivery of what lies ahead. I will now go to the sideline and watch with interest how it all plays out. I'm grateful, of course, for the kind remarks that you, Mr. Mount, and you, Ms. McCartney, have made. I wish everyone well. Tēnā koutou, tēnā koutou, tēnā koutou katoa. Kia ora.
Tēnā tātou katoa, he tū tēnei ki te tuku mihi. Kia koutou o Ngāti Whātua o Rākei, mua I te ako nei ka hoatu te rākau kōrero kia koutou, kia whakaoti, a pai tēnei nohoanga. Engari, kei te tautoko o ngā mihi kua mihi aki a koe te te mana, kei te mihi ki a koe hoki I o kupu I tēnei ai. I ngā rā iwa ko pahure, ko ki te tātou, ko rongo tātou, I ngā karearoto, ngā kōrero, o rātou ko kuhu mai tēnei whare, kia kōrero mō o rātou whiako. Ko rongo hoki, ko kite hoki, te maia, te kaha, te manawa nui a rātou, ki te mahi tērā mahi mua I te aroaro o tātou I tēnei nohoanga, no reira kei te mihi ki a rātou. I te rā, I te ahi, ko koutou tērā Ngāti Whātua o Rākei hāpai ana I mātou mahi ana I tēnei mahi, no reira, ko tēnei te mihi ki a koutou. Hari te mea ko tēnei kaupapa anake te kaupapa nui o tāmaki nei, o tēnei rohe, ko koutou tērā I tautoko ana, e hāpai ana I ngā kaupapa kato o tēnei rohe. No reira, mo tērā tēnei te mihi nui ki a koutou. Hari te mea, te take o tēnei tū kia roa te kōrero, engari kia mi kau ana ki a koutou, mai mātou o tēnei kahui pūwhero a Rapporteur Royal Commission of Inquiry. No reira, tēnei te mihi aroha ki a koutou, e ki ana ngā manoa I te aroha, ahakoa ngā pikime ngā heke I tēnei nohoanga. Mo koutou tērā e whakapapa pau namu te wai, mā tātou mo tēnei waka kia pai ai te āre o tēnei waka. No reira, tēnā koutou, tēnā tātou katoa.